person. Rick, welcome to the show.
Good to be here. It's good to be anywhere where there's air conditioner today.
That's right. Well, I know you've done your studying. You've got all sorts of information to tell us. What do you got going on?
Well, on this situation, you talked about the sentinel, and that a little bit of a warning on the sentinel part. That sort of indicates that you're ready to do something, and this is really more of a spur of the moment kind of penal code here. Not that you can't use this defense if you are standing sentinel, but the key here is when you read this, the actor reasonably believes. It doesn't really matter what the facts are. What really matters is what does the actor reasonably believe. And of course, when you have a jury listening to the actor, if that actor is believable, then the jury is more likely to believe what he reasonably believes. So of course, you read section 931 and section 932. That's the self-defense and also the deadly force areas of the penal code. So basically what you've got here is a third person standing in the place of the victim. So he can use this force, and he can use deadly force if he reasonably believes to be threatened, if he does. So basically if the victim has that situation, or if he reasonably believes the victim is in that situation, then he can stand in. So some of the case law talks about that a person acting on behalf of another to prevent such other from being murdered, ravished, robbed, maimed, disfigured, or from substantially serious bodily injury, then he's entitled to use the same justification under law as he would if he were the person that was being done all those things to. So basically one has the same right to defend the life of another or the body of another as he would his own.
And that's, well, but when it comes to the sentinel part, what I meant by the sentinel part was this, Rick, that you're just prepared. You're aware. So if a person's just prepared and aware, and a situation comes up like you just stated, and he feels as though this person is in danger, he was just prepared and aware because he one knows what to do, he's prepared, or she knows what to do to handle themselves, and we're aware and saw a situation happening. They're not looking for it, they're just aware. So
Oh, sure, absolutely. I mean, I had a psychiatrist tell me a long time ago, he said, we can all act like we're some sort of heroes and we're the best in the world at what we do. But when you get right down to it, if you do your clinical business, if you take care of your knowledge and you learn the basics and the fundamentals and you're prepared, then you will be a winner. And he's talking about all professionals, whether they're doctors, lawyers, people who protect the public from bad people. I mean, any of those professions. You just got to be aware and got to be taking care of business.
Rick, I want to ask you something. I talk about this in my class, and I say, you have to be careful when you defend a third person because the third person is the variable. You never know what's going to happen. No one can guarantee the actions of another, to quote Spock on Star Trek, okay?
Absolutely.
So here you are, you're thinking, your reasonable calculation is that this individual needs assistance. Come to find out, the person's going to oppose you because they don't want all the hype or the media coverage about being protected and wants to get out of it and say, I never asked him to help me. How can this turn on its head? A good Samaritan wanted to defend a third person. What things could be bad for that person? Does that make sense, the question?
Well, yeah, there are a number of, the devil is in the details. And this penal code begs for you to present few details. In other words, if you are in a situation where you provoke another person, or if you're in the commission of a crime, you do not have the right to defend yourself with using deadly force. So if a third person comes along and he knows those details, then in his position, stepping into we'll call them the victim, even though they aren't the victim in this scenario, he doesn't have the right to use it. But if he's unaware of those things, remember what I said, it's what he reasonably believes.
Can we use a simple thing that I think we've heard not too long ago? Individual didn't make car payments, so his car is getting repoed. But
yeah.
the repo vehicle is not really distinguishable. It looks like his car is getting jacked. So this guy comes out to defend him, and he's defending the person whose car is getting jacked. In reality, though, is he in some type of violation? Would that be an example of what you're trying to say?
Yeah, exactly. And that's why the court in that situation said that he deserved to have the instruction given to the jury about him being able to protect someone else's property.
Would you give any type of checklist of things that you would put mentally in your mind as to, hey, certain scenarios happen, this is what I'm going to do, or is that just almost impossible to do?
You know, again, most of these defenses happen in situations where the victim and the third person know each other, but not all of them. The situation, for instance, you just brought up was one where they didn't really know each other. So sometimes the details, like I said, or less, then you're better off. If you know some things, then you can't, and that would not give you the right to defend yourself, then you can't defend that third person.
When you're limiting the information to yourself, doesn't that also flip back on you and say, well, you know, you were kind of abrupt, you didn't really step back to analyze what was going on? Can that come back at you too?
Well, it can, but you know, this is a situation where quick analysis is important. Because basically, what you're looking at is an imminent danger. Okay, remember that. That's part of what you just read. The imminent danger. For one example, a fellow has his prescription medication stolen from him, and the next day he goes and basically enters the habitation of the person that stole his prescription medication, and he doesn't kidnap her, but he restrains her, which, under Texas law is a kidnapping. And he tried to use this as a defense because she was pregnant, saying, well, there was imminent danger to the fetus. And I've got another comment after this, but basically the court said, no, you had overnight to think about it. If there was imminent danger, you may have acted immediately, but you couldn't sit around for 24 hours and then go, wow, immediate danger. I need to go protect the fetus, so I need to go in there and burglarize and kidnap this pregnant lady to protect the fetus. So no, you gotta act quickly. I mean, it's an imminent danger, so the imminent action is required.
That's what I do on pot, everybody, is a good thing. Pot, perception of threat, right? And looking down and saying, hey, this is the perception I'm seeing. It's time to move based on my perception of the situation. Did you have some other footnotes concerning that?
Well, yeah, just to comment about the pregnancy. In Texas law, and I'm not talking about religion or politics, I'm talking about the law in Texas, a fetus is not considered a person. So the idea that you're going to protect a fetus under this law is not a good idea. And there's quite a bit of case law on that with regard to people going to abortion clinics and blocking the way and actually assaulting people that work there. This is not going to give them any kind of a defense because in Texas law, a fetus is not a person. And as you read, it does require a person under imminent threat.
And understand, fetus is not a law in the state of Texas. If you don't like that, scream, push it, and make it into law where it becomes a person. But right now, the law states this, so you have to go based on what the law is saying to win.
And of course, there's been a body of legislation regarding that matter, and of course, the penal code now allows for murder charges for a fetus. But I think the reason that the law is the way it is because there's a lot of lobbyists down in Austin who does not want it changed because in the civil situation, there's no cause of action for a fetus.
It just makes my skin crawl.
Well, that's tort reform.
Okay. All right. This was relatively an easy penal code to decipher. It's basically, I look at it like this. If I can do it for myself, I can probably do it for the other person.
Well, that's exactly what it says. And in fact, you might even not be able to do it for yourself because you don't know all the facts. The question is what you believe the facts are. So if you believe the facts are such that you can do it for yourself, then you can do it for the other person.
Right. I just thought my lingo, my 50-cent words, kind of makes it simpler to understand than reading this legalese stuff. All right. You had something else you wanted to go over too. We got a little time here. Did you want to hit that?
Well, you had mentioned a few days ago a situation that was on the in the Temple Daily Telegram about a man here from Cameron who was arrested for shooting at a stabbing suspect. And you were talking about how, sometimes doing good doesn't necessarily mean good results. Well, for this gentleman, it did not mean good results, absolutely. But I did want to point out that, he had a blue warrant issued for him. He was arrested probably more so because he was on parole, and him having a gun would have been a parole violation. I'm not sure he was necessarily arrested because he did take a couple shots at this bad guy that was running away from the stabbing victim. But then also you got to be thinking the guy was running away. So there was a couple of reasons here maybe that this guy wasn't doing so good.
The biggest thing I think I've learned from you and Ross, Rick, is that the law that's written in the book really doesn't mean much, because you've got the attitude of the jury, the information that's decided to go in or out of a case, the attitude of, I guess, the judge. These things, this black and white that's on paper that I'm looking at right in front of me right now, can be distorted, twisted, manipulated. So you've got to understand it and realize right here it can be manipulated, right there it can be twisted. So you have to take that into your consideration when you're going to do anything, right?
Well, as an attorney, I take offense to those twisted and manipulated words. We do have black and white law here, and we do have the words imminent, and we do have the words that indicate that we step into the shoes of someone else based on our own belief. And those words are then defined, massaged by the appellate courts that give us more information about what these black and white statutes mean. And that's what lawyers do, is we read all those cases that were precedent so we can get a better feel for exactly what each one of those words mean.
Let's go back to a topic that I'm very well versed in, okay? And that is guns. Before C.J. Grisham got arrested, I've said this many a times, I would ask 10 officers, can you have a rifle in your vehicle? I would get 10 different answers. Everybody knows now, as long as you're not doing it in a threatening manner, that long arms are fine. Okay, you can have them in your car, you can walk down the street, as long as you don't do it in a threatening manner. It's basically, shoulder, whatever.
But you see, what's the definition of threatening manner? I mean, I sort of feel threatened when someone's walking down the street and they have an AK-47 strapped across their belly. That's just me, though. Hey.
Well, it all depends on the man. If the guy's carrying it in a position where he's ready to fire, but if he's just walking down from point A to point B, you got to understand the right exists for him to be able to do it. I must accept that.
I agree.
Until that changes.
That doesn't mean I'm not threatened.
Okay, whatever. But here we go. Now I'm getting my instructor training down in Austin, where the heck was I? It's like Georgetown. Okay, I'm getting my instructor training. And I'm thinking the most simplest part of the law is Penal Code 30-6 and 30-7 and verbal command. 30-6 is you can't go in there with a concealed weapon. 30-7 you can't go in there with an open carry weapon. And verbal communication from somebody in apparent authority for the owner, or the owner himself can say, hey, look, if you got a license, I don't care. I don't want you on the premise with a firearm. Then they screw it all up. Here you are, you're training your students. It's black and white. It's simple. The state says it's got to be certain words specifically to make it legal. And then they're promoting and they're saying, well, if somebody puts one of those Ghostbuster signs up, they weren't there, but that's kind of, what they're thinking. That does not fly with me, Rick. And that's a muddlement of, that's a word, of what the law is saying. It puts confusion on everybody. And it gives me the concept idea that a lot of law enforcement don't truly know the verbiage of it. And it puts us back in a position of having to worry about getting hassled or potentially arrested because we didn't obey a Ghostbuster sign, the circle with the slash in it, as compared to what we are taught and learned, and it's in the law, 30-6, 30-7, or a verbal command from the owner or somebody in apparent authority from the owner. What do you say to that?
Well, I say that when you have 12 people on a jury, you can get different results at different times. But because these laws have these words in them that do allow a question of fact, and the question of fact in this situation we're talking about is what a person reasonably believes. I mean, we know what a person is, but the word reasonably believes, that can have different connotations. And then you got the question of truthfulness. So when you're in the courtroom and there's someone on the witness stand, I mean, are they always telling the truth? We have a lot of situations now where eyewitnesses we find out that they're not as reliable as they should be. We have situations where some of the science that we used to deal with in like teeth mark identification used to be something that was really useful and relied upon, but now we find out that the teeth mark identification is not as reliable. We have situations where arson, as science and technology comes up, we find out that the signs that we used to think were arson are not arson. It's different. So things evolve, and not only do these science and these thoughts evolve, and the law evolves with it, but we get back to those 12 people on the jury, and they have to analyze all these questions of facts. That is their job. And as long as the courts do their job, and that is allow them the instructions and the information that's required, and like some of the cases that I looked at here to visit with you today, talk about the instructions. You have to know that things ain't always the same, because they're never the same, okay?
I don't know. I'm scratching my head on that one.
Well, I mean,
let me
okay, if you have 3 nuns and the priest testify that they saw the light red, that's going to be different than if you have the brother of the victim who has 3 felony convictions. You would agree with that, wouldn't you?
I guess. I'm more focused on this one example I'm trying to give you here.
Okay.
Let's say there's 2 glass doors. They slide open, okay? And on it, there's 2 scenarios. The first scenario is, on the glass doors, there's a Penal Code 30-6 sign, properly written in English and Spanish, bold colors, contrasting colors, at least 1 inch in height, the way they're supposed to be. I come up to the door, I say, I'm a licensed to carry, I understand the law, I've been taught the law, I sign my affidavit saying I understand the laws, I turn around. I come up to another set of doors, 2 glass sliding doors, and the only thing on them are Ghostbuster signs, circles with a slash bar. I go in there with my open carry pistol. The person gets fired up, calls the police on me. The officer comes. I said, hey, look, I didn't know. These signs don't pertain to me. He didn't tell me to leave yet. He just called the cops on me, and I get arrested. Is that right or wrong?
Well, that would be wrong, and I'm sure that you would get acquitted in the court of law.
But I got to go for jail. But I got to go for the ride. What I'm saying is, the being taught like I was taught, or being advised like I was advised, when I went to this instructor place, gives me the impression, because he said it himself, the instructor, DPS officer, 33 years, said it himself, that this is how we think. If the sign's up there, that's basically what they're thinking. However, that's not the law. So it causes problems for people out there, and I'm just saying, to what point do you just say, hey, sorry, your opinion don't mean squat, it says it here plain as day, but why do a lot of people have to go for the ride anyway? I don't know.
Well, because it's the police officer's decision. And, of course, the police officer has a lot of discretion, and that's why, as I said before, the police officer's name is either sir or ma'am, and the answers are yes or no, sir, or no, ma'am. And anything beyond that, you're giving them too many details. And since the devil is in the details, let's keep the details out of this until you get an attorney.
You're on your own, everybody. You're going to carry that gun and you go into a sign. Let's say the store doesn't even have a sign. Who knows? Maybe you'll get arrested too.
Well, you need to use your discretion. I mean, obviously, if they don't want you in there with a gun, and when I use the word obvious, they may not have the correct, proper, legal sign up there. But they've got a sign up there, and you look at that and you go, gosh, obviously they don't want me in here with this gun. You probably ought not do it.
I disagree.
Well, I mean, you're just a rebel. And you don't mind spending the night in jail. I'll come get you out.
Okay, sure. I'm just like, I study this, I know it. If I got to jump through hoops, they got to jump through hoops. That's just the way it is.
Well, that's
why write the law?
That's
Rick?
the way it's supposed to be, okay? I agree with you.
But if we all go, well, whatever, then it never becomes it. If we go, if there's a standard SOP we can all live by, I think that would make everything a lot better. A lot smoother.
Well, of course, your education in this kind of radio show helps people. It does. It helps people understand. And I'm not talking about just the people that are carrying the guns, but the people on the other end. For instance, a couple, 3 years ago, if I had seen somebody walking towards me down the sidewalk with that AR-15 strapped over their shoulder, I very well may have called the police. But today, I would just, walk to the other side of the street.
A lot has to do with the body language, the way the individual's acting. I mean, now there's a lot of people out there, they have the right to carry it and they're idiots, okay? And if they do something in a manner that is threatening, by all means, I mean, that's just foolishness. We were talking about this with Ross last week concerning knives. You know, the atmosphere here is you may be legal to carry 2 samurai swords and crisscrossed on your back, but, you know, people ain't prepared for that. But down here in Texas, a shotgun in the back window of the truck, just 10 years ago was okay. And then everybody started freaking out, and now we've got to the point again where, hey, you can do that. Just do it in a very professional, common sense type of way, and don't be causing alarm.
Absolutely. And, you know, that kind of goes along with this person's assessment of the situation when we get back to this third party. You know, some of the facts that a court may not allow that person to put into evidence may be important, and then that's why the appellate courts get to review it. For instance, in a situation where a fellow was protecting his brother against an assailant, the court would not allow him to put into evidence what this same assailant had done to his father 2 months earlier, because they said, well, that's too remote. But it was important for the jury to know so that they could understand how the defendant thought and how he reacted based on what he knew that this assailant was capable of doing, because this assailant had done it to his father. So that case was reversed, remanded, so that the new jury could hear it along with that important and salient information.
Do you have any case or story concerning Penal Code 933 off the top of your head that you've been familiarized with around here anywhere? Of defense of a third person?
Well, the only one that I knew of was this information here with the man arrested for shooting at a stabbing.
Ladies and gentlemen, bottom line is this. If you're going to carry, you don't even have to carry, but if you're just aware of your surroundings, it's like the 3 A's I always teach. It's acknowledge there's a threat. There's a threat no matter where you go, to some degree or level or whatever. Acknowledge there's a threat. Be aware of your surroundings and avoid the situation if at all possible. The 3 A's. It's not AAA for your car like the lady on the 911 call. It's AAA, acknowledge there's a threat, be aware of your surroundings, and avoid it if at all possible. And if you can't avoid it, you should be well versed and well learned on your penal codes and how to basically handle yourself and your weapon to maximize its efficiency and minimize any type of mishaps that may come around, like injury to an innocent third person, reckless injury. You want to avoid reckless injury at all costs. And the way you minimize that is with practice. And you can come to my range to do that.
One thing that we know about self-defense and defense of the third person is that they are difficult defenses. The majority of those kind of defenses are lost in the courtroom. And of course, probably because prosecutors only prosecute those cases where the facts are pretty much against the defendant. I mean, and that's true always, and that is their job. It should be their job, because if the facts are clear that the person is innocent, then the prosecutor should prosecute, right?
Right.
Okay, so we know that, but we also know in stand your ground states nationally that you are twice as likely to win in a self-defense situation, because the stand your ground gives you more leeway. And I thought that was interesting when I read about that.
The stand your ground law has come into effect for a reason. It's because people feel, or have felt, that they're not being protected as well as they could be. They don't have the opportunity to protect themselves, and this just gives them one more step to do that. However, you got to be responsible in how you do it.
And that's my point. You were talking about the nuances of the law and how we can be confused. I think basically the stand your ground law helps clarify some of your rights.
Rick, we're about out of time. Tell everybody what you do and how they can get a hold of you in case they need your services.
Well, one of the things I do, of course, is asbestos law, but if you note on the ad that came a while ago, we do birth trauma law, and that's kind of why I know a whole lot about this abortion this fetus being a person issue, because I saw the evolvement of that in tort reform starting back in the late 80s. So we do birth trauma law. We represent people who've been in truck wrecks, and you can get in touch with us at respectforyou.com.
And ladies and gentlemen, on the first commercial break, you probably hear the ads. So pay attention to it and take some numbers down.